हेलो दोस्तों लेट्स डिस्कस मेसर्स दिल्ली बॉटलिंग कंपनी प्राइवेट लिमिटेड वर्सेस सीबीसीबी सेंट्रल सीबीपीसी सेंट्रल बोर्ड फॉर प्रिवेंशन ऑफ कंट्रोल ऑफ वाटर पॉल्यूशन। तो दोस्तों इट्स 1986 जजमेंट बाय दिल्ली हाई कोर्ट। इसमें हुआ ये था। अच्छा दोस्तों, इट इज़ अगेन रिलेटेबल टू सिटीजन सूट प्रोविजन दैट वी रेड। तो वी जस्ट इन दैट वीडियो वी सॉ that before enactment of Section 19 of Environmental Protection Act 1986, there was no provision for citizens to approach the court. That means that it's the government official who will approach the court. तो इस केस में हमने ये देखा कि इट्स 1984 में CPCB अप्रोच्ड मेट्रोपॉलिटन मैजिस्ट्रेट सेइंग कि ये जो कंपनी है जो द पिटिशनर इन दिस केस इट्स रिलीजिंग एफ्लुएंट्स इन द रिवर यमुना which is contrary to the consent order under which it was granted the license. So accordingly, the Metropolitan Magistrate passed an order restraining it, that till the time restraining it from releasing effluents, till the time it erects a treatment plant or effluent treatment plant. So दोस्तों, now this petitioner has filed a Section 482 petition to quash the order of MM. तो दोस्तों, इट्स इम्पॉर्टेंट टू refer to the relevant provisions of Section 21 and 33 of Water Act, because that is under which the entire case revolves. So दोस्तों, Section 21 deals with power to take samples of effluents and procedure to be followed in connection therewith. And दोस्तों, so Section 32 and 33 are the sections under which the CPCB can make an application and to make an application or petition before the court. So 32 deals with the power in case of emergency and 33 deals with power in case of normal circumstances, in case of apprehended danger. So Section 33 is titled as Power of Board, that is CPCB, to make application to courts for restraining apprehended pollution of water in streams or wells. So CPCB made an application under Section 33 and Section 33 is subsection 1. So accordingly, a sample was taken from water. Now this is a case on procedural ground. So the procedure in Section 21 that we read, Section 21 subsection 2 says that no evidence, whatever is collected as a sample, it won't be admissible as evidence unless the subsection 3, 4 and 5 of Section 21 are followed. So in Section 33, as we can see that since there is an application to court, it's a legal proceeding. So the main contention of petitioner is that the provisions of Section 21 were not followed. And what are the provisions of Section 21? So one of the provisions says that when a sample is collected from the stream and one of the representative of the company is present and he asks for it, then the sample will be divided into two parts. One part will be sent to one laboratory and the other will be sent to other based on the request of the petitioner. Obviously, it cannot be his home laboratory, otherwise, but it will be some of the recognized laboratories. So this is just to make sure that there is less error. अगर दो labs दोनों बोलेंगे कि हाँ भाई इसका sample the concentration exceeds the permitted concentration of pollutant, तो गड़बड़ होगा. So here in this case, the MM said that there was no one from the side of company and nobody asked for it. इसलिए अगर दो part में divide नहीं हुआ तो that is okay. But the High Court, based on the record, comes to a different conclusion. It observed that the other party was continuously present. He made an application for it. Still, it was not the sample was not divided into two parts as required by Section 21 subsection 3. तो इसलिए so दोस्तों, we can disagree with the case that just for the sake of some procedural technicality, the substantive justice was denied or delayed. But the thing is, these provisions are inserted for the sake of natural justice. So maybe one laboratory के equipments are a bit flawed या कुछ उसमें गड़बड़ आ गई, कुछ human error आ गया. तो जस्ट टू मेक श्योर दैट द अदर, और उससे अगर सपोज उस ह्यूमन एरर की वजह से वो इंडस्ट्री रेस्ट्रेन हो जाती है तो समबडीज राइट टू लाइवलीहुड माइट बी एट जेपरडाइज. तो इसलिए इसको इससे बचने के लिए उसमें दो सैम्पल्स के प्रोविजन थे. तो इट इज़ ऑल अबाउट बैलेंस. इट्स ट्रू, लाइक आई रेड समवेयर दैट doing justice framing the law is easy, doing justice is difficult, but doing justice according to law is all the more difficult. So here it was all about doing justice according to law. So दोस्तों, आई होप आपको ये समझ में आया होगा. मिलते हैं एक नए वीडियो में एक नए केस के साथ. टिल देन, बाय बाय.